We're going to begin with some breaking news this afternoon in relation to the so-called Medivac laws. The laws that make it easier to transfer sick refugees and asylum seekers from Manus Island and Nauru to Australia. You may recall these laws were passed through Parliament against the government's wishes at the start of the year. The government didn't have the numbers in the House to stop them. Labor joined with the crossbenchers to force these laws through. Now, under these new arrangements, 2 doctors in Australia can recommend a patient be brought to Australia after consulting them either in person or via Skype. If the minister rejects that application, then a special panel of doctors sit in judgment. The minister can still overturn any transfer, but only on narrow grounds of national security reasons or if there's a serious criminal conviction recorded. Now, the laws came into effect on the 1st of March, and in the 3.5 months since then, dozens have been transferred to Australia under the Medivac system. Incidentally, I understand more have actually been transferred under the old system, which remains in place during that same window. But from early next week, that's expected to change as the rate of transfer under the Medivac system increases. But the breaking news this afternoon relates to how this law will now operate after an important federal court ruling yesterday. This is a ruling from Justice Mordecai Bromberg in relation to a 29-year-old man from Iraq who arrived in Australia by boat 6 years ago and was sent to Nauru. The ruling is that he now be brought to Australia. What's relevant here is how the Medivac law has been interpreted by the federal court and whether indeed the 2 doctors recommending the transfer need to actually consult the patient at all. Now, as mentioned, the legislation referred to a consultation being required, either in person or via telemedicine. But the court, in this federal court ruling yesterday, has ruled the doctors in Australia don't need to personally engage the patient at all. Take a look at the key elements from the judgment. This is Justice Bromberg saying, "I would not conclude from the available textual and contextual indications that personal engagement between the treating doctor and the transitory person was intended as a mandatory requirement for the assessment required in order to gain entry under the scheme established by the Medivac provisions." Goes on to say, "It has not been demonstrated that even in an ordinary domestic setting, let alone the transnational and urgent setting in which the Medivac provisions are intended to operate, that personal engagement between doctor and patient is a necessary condition of legitimacy for a medical assessment." So the key line referred to again and again there is personal engagement between the doctor and the patient isn't necessary. This is a significant ruling from the federal court. The view within the government is that this means no consultation is now necessary at all. The 2 doctors can simply look at a patient's file, look at the notes, and recommend a transfer. There is a concern within the government that there will now be an acceleration of transfer applications, particularly for the backlog of more than 200 cases that doctors have identified on Nauru and Manus Island that they want addressed. Now, it's true the government did warn the floodgates would open when this law first came in, and that hasn't necessarily happened. It also warned that pedophiles, murderers would be transferred to Australia. That hasn't happened as far as we know. And it's true that any transfer the minister rejects would still have to go to a panel of doctors to consider and can only be overturned on narrow grounds of national security. But this federal court ruling does mean the transfers will now be easier without the need for an actual doctor's consultation before a recommendation is made. Now, I understand at least 10 previous cases that were ruled invalid because the patients had not been consulted by the doctor now could become valid and will have to be reassessed. The Home Affairs Minister Peter Dutton has long maintained that these Medivac laws were only introduced as a political stunt to embarrass the then minority government at the start of the year before the election. He says they're flawed laws, they can't be fixed, they must be repealed. The government will seek to repeal the laws when Parliament returns in a couple of weeks. Labor is so far standing by the Medivac laws, though, and my understanding is the opposition is well aware of this federal court ruling yesterday and its implications for how the Medivacs now work, but Labor still believes there are enough safeguards, adequate safeguards, given there's still the requirement for the panel of doctors to make a recommendation if the minister doesn't want a transfer to happen.